All right, everybody, how's it going? This is Immigration Attorney Moumita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind today. Thank you so much for joining me. My name is Moumita Rahman, and I'm an immigration attorney. I have been practicing immigration law for the past 15 years, and it is my pleasure to do the work that we do because I believe that immigrants make America great already. So thank you for joining my live. Welcome to my channel. Hello to everybody. Hello, Covered by God. Hello, Jackie. Hello, Mike Loud. Hello to everybody who's joining today. Let me know what question is on your mind about immigration because I am going to do my best to answer as many questions live that I can tonight in the time that I have because I know that there's a lot going on and there's probably a lot on your head, on your mind. So let's talk about one important question that I want to discuss with you about your expired green card and whether or not it's too late to file your I-751. But before I answer this question and I go into other questions that are on your mind tonight, I do want to say that our telephone number is 212-248-7907. And although I am based in New York City, we work with clients all over the US, so it does not matter to us where you are located. As long as you're okay with us being here in New York, we work virtually with clients all over the country, so it does not matter to us. Hello, Cassava from Chicago. Hello, Bismay. Hello, Hector. Hello, Rosalindo. Nice to see all of you today. Go ahead, give me a second to talk about this topic before I start answering your questions live. So let's talk about it. If your green card is expired, is it still possible to file for a new green card? Is it still possible to file for an I-751 or for an I-90? This is something that is really important. Today, I'm going to talk about the renewal, basically the removal of conditions if you have an expired 2-year green card. Now, first of all, what is a 2-year green card? A 2-year green card is just a green card, except it has a condition upon it that it is only valid for 2 years. And you would get a 2-year green card if you got your green card through marriage to a US citizen, but at the time that your card is approved, you have only been married for less than 2 years. So what the government does is they put a condition on your green card and they basically want you to jump through another hoop to prove that your marriage was made in good faith, to prove that your marriage was real and you didn't just have a green card marriage. So what they do is instead of giving you a 10-year green card right away, they give you only a 2-year green card with the condition that you have to apply to remove conditions before it expires. However, what we know about divorce and about marriage is that marriage is very difficult and divorce can happen or separation can happen. And especially if you are an immigrant who has basically obtained your green card through marriage, you may be going through a lot of things in your relationship. You may be getting controlled by your spouse. Your spouse might be saying that they want to divorce you. Your spouse might be cheating on you. Your spouse might be putting you through a lot of misery. And what happens to a lot of people that I have seen is that by the time that the green card is issued, things can be okay. Things might still be a little bit rocky. But after the green card has been issued, life becomes even worse. Life becomes even more difficult and you might suffer a lot more. Your spouse might get mad at you even more all the time. They might start accusing you of only marrying them for a green card, or basically they know that you are still reliant upon them for your immigration status and they start treating you even worse, right? So what happens if you're in a marriage, you've gotten your 2-year green card, you've won, you've overcome that hurdle, but by the time your card is expiring, your spouse leaves you, or they file for divorce. They tell you they're not going to go anymore, or you just have lost all hope and your card expires and you still have not applied to remove your conditions. Can you still apply to remove your conditions even if your card is expired? And the answer is yes. Even if your 2-year conditional resident card has expired, you may still be eligible to file the removal of conditions through the form I-751. And the reason for this is that if you are asking USCIS for a waiver of the joint filing requirement because, number one, you have gotten divorced from your spouse and you have a divorce certificate, or number two, because you have suffered extreme cruelty or hardship during the course of your marriage, then you might be surprised to learn that there is actually no deadline at all. And it doesn't matter how long ago your 2-year card expired, you still have the right to file your I-751 with a removal of condition waiver, okay? However, what I do want to say is that if you are still together with your husband or wife and you're doing a joint application, that's when the deadline is super important, because if you and your spouse are still together, the relationship is still good, and they're helping you with your process still, you have no intention of doing this separately from your spouse, then that is when the expiration date on your card becomes super important, and you do have to abide by that. Now, even if that expires, because what a lot of people do is they forget to apply, or they file the wrong application, they file the I-90 instead of the I-751. And if that happens, you can still actually file your application late. However, you do have to give a reason why it's delayed, okay? And if you are going through this process, and you have an I-751 that you want to file, but your spouse is giving you a hard time, you're not sure what the future holds for you and your spouse, it is time to explore your options. Do not wait until your card is expired or about to expire before trying to figure out what your options are. Okay, you can give us a call, 212-248-7907. Okay, and Jovan is asking a good question. Jovan is asking, will I-751s get harder to approve underneath the new administration? What exact documents are they looking for? Any general tips that you can give for success? That's a great question. So in general, I-751s should not be getting any harder to approve underneath this new administration. But here are some tips for success. Number one, whether you're filing with a waiver or whether you're filing jointly with your spouse, USCIS is going to want to see lots of joint documentation of your marriage. And the gold standard to them is going to be joint taxes, joint bank statements, joint utility bills, joint returns, all of these things, joint, right? So if you're filing a joint application with your spouse for an I-751, you definitely want to have as much evidence as you can. And keep in mind that they're going to want to see evidence for the past 2 years, right? So if you've had your green card for 2 years, then they're going to want to see evidence throughout that time. Now, if you don't have a lot of evidence because your spouse was controlling everything and you just never got your name on the accounts, or they don't want to share access with you, that is a sign of control, and that is a sign of financial control, financial manipulation, and there's probably other things that are probably happening in your relationship. And if that's the case, then it's a really good idea to explore the I-751 extreme cruelty and battery waiver, because a lot of times, because the extreme cruelty and battery waiver for the I-751 is underneath the VAWA law, it is the standard of evidence is any credible evidence. So we are oftentimes able to explain a lack of evidence because of that. Okay, 212-248-7907. Okay. After submitting, Yoli is asking, after submitting an I-360 and receiving a prima facie, what happens next? Yoli, that's a great question. If you have files for VAWA and you got your I-360 prima facie determination, the next step is going to be a lot of waiting. Alan, thank you. I'm going to see your question in a sec. Once you get your prima facie determination, then usually you'll receive your work permit if you filed your I-765 within about, let's say, 5 months after that, approximately. And then after you get your work permit, it's like 2 years to 3 years of radio silence from USCIS. Sometimes they give you a request for evidence, and sometimes they just give you your decision, okay? Ruby, muchas gracias for the rose. Okay. Yvonne, thank you so much. Let's see, Ruby Suarez is asking, I'm a US citizen, can I petition for my parents? They came through the visa waiver 20 years ago, from Ruby. Okay, Ruby, this is a great question. If you are a US citizen and you want to petition for your parents, the number one question that I'm going to ask is, what status did your parents enter through? Because oftentimes when you want to help your mom or your dad, when you're a US citizen, you want to help them get their green card and get their papers fixed, the number one obstacle in the way for a lot of people is basically their manner of entry. Because when you apply for a green card, you usually have to show that you have a entry with inspection. And if your parents entered with a visa waiver, then that is going to be considered an entry and inspection. And you should be able to apply the adjustment of status process for them. Now, there is one little consideration for persons who enter with a visa waiver. The main difference between entering with a visa waiver versus entering with an actual visa is that if a person's adjustment of status gets denied, then there's no right to appeal it, and there's really nothing you can do. However, I can say confidently that we have filed in my office several applications for adjustment of status where the client's relative entered with a visa waiver, and that's not been an issue. Okay, if your parents don't have any other issues, they don't have any fraud issues, no criminal issues, you have enough documentation to show that you can financially support them, then you as a U.S. citizen should have a relatively straightforward time sponsoring your parents for adjustment of status, aka for a green card. So Ruby, feel free to give us a call, 212-248-7907. Now again, because your parents entered with the visa waiver instead of a visa status itself, basically the thing to consider is like what happens if it gets denied, but that's why we have to make sure the case is airtight before it's filed, okay? Jenny's saying, respectfully, you make everyone believe they can falsely file a VAWA. Jenny girl, I don't know who you are. I don't know why you think that I'm saying that. I don't know. I mean, anyone who follows me knows that I'm not saying for them to file falsely. What I am saying is that when you have suffered at the hands of a U.S. citizen, whether it's your spouse, your child, whatever it is, you have the right to file for VAWA. So, it's funny because a lot of people who get upset about me talking about VAWA tend to be a little bit abusive themselves. So I'm sorry that you think I'm telling people to file false VAWAs. Simply not true. And for anyone who wants to say that, we have lots of processes built into our office where we interview clients for hours, and we use those notes in order to create their case. And that's why we tend to get our cases approved. All right, Angel is asking, I have a marriage-based green card application coming up. Any tips, please? Angel, that's a great question. And Angel, I'm going to encourage you to follow me on YouTube because I have lots of very long videos on how to prepare for your green card interview. The main advice that I can give is that if you are filing for a marriage green card and you have an interview coming up, prepare. You have to prepare your documents. You have to have evidence. You need to go over your history, your dates, your how we met story with your spouse. Don't think that just because you have been together for a dozen years that everything's going to be fine. People tend to forget the most important things. Most people are not going to be able to tell you off the top of their head what their first date was and when it was. Even most of the times people have different ideas of what a first date was because not everybody has the traditional first date story. Some people are friends for a long time. Some people meet through family or they know each other since they're kids. So you have to go over your how we met story. You have to know like when did you first lay eyes on each other? When did you first go on your first date? Or when did things become romantic? When did things become serious? These are some important pieces of information that the officer is going to want to know. Makeup by Tony, November 2024, got notified by my spouse that my spouse and I are documentarily qualified and we're still waiting for my interview date. It's been 4 months. Makeup by Tony. So once your case becomes documentarily qualified at the NBC, usually it can take anywhere from 1 month to 6 months, sometimes more, in order to get your interview date because of the fact that your interview date is going to depend on time slot availability at the consulate that you're going to. And sometimes they prioritize certain case types over others. Sometimes they prioritize spouses or parents, but also like if there's any sort of closure, those sort of things will affect how quickly you can get an appointment. Adri Herrera, I haven't heard anything for 3 years and I've done so much. What to do? Adri, I'm guessing that you filed for VAWA, and if you filed for VAWA but you have not heard anything back on your case, this is not a reason to worry. Just because you have not heard anything on your case does not mean that you've done something wrong or that your case is going to get denied. It really just means that there are so many cases at the Vermont Service Center that by the time a case gets by the time an officer gets the chance to even look at your case, to properly read your case, there's just a long waiting time. And right now, that waiting time is approximately 3 years, 3.5 years. Can you get documents if you get assaulted from Cute Elite? Cute Elite, if the assault was relatively serious, then you may qualify for a U visa. But to qualify for a U visa, if you have suffered a serious sort of crime, then if you have reported the crime and it's a qualifying crime, and also the law enforcement agency signs off on a certification, then you may be eligible to file for a U visa. The U visas are taking like almost 10 years to get approved, but it's still better than nothing if you don't have any other option, okay? So QELI, you can give us a call, 212-248-7907. I had a question also from someone earlier asking if PD is still an option. PD is not totally gone. It's just going to be harder to get. And we're still asking for prosecutorial discretion on certain cases. Rainbow Romance, thank you for the follow. I received a U visa bona fide work permit, but never received the approval notice from Doabale. Doabale, that's you're not approved yet. If you get, if you filed for a U visa and you got a bona fide work permit, that doesn't mean that your U visa is approved. It just means that they gave you bona fide determination, and that's usually a letter, and it's not an approval notice. Okay, so if that's what you're talking about, you should have gotten an approval, a bona fide determination letter. Applying for citizenship, and I had a misdemeanor 22 years ago. Green card is 87. Do you suggest to attend an attorney? 100%. Even if you're applying for citizenship and you have any sort of criminal history, you should work with an attorney. It does not matter how long ago your charge occurred. If you have any sort of criminal history, you have to get your case analyzed and you have to make sure it's not going to be a problem. Now, anytime you have had any sort of negative encounter with law enforcement, you want to be upfront with your attorney. You want to disclose this, and you want to try to obtain records. Even if things get dismissed or expunged, that doesn't mean that records don't exist. It just means that you have to work a little harder to get it. But attorneys need to be able to analyze these documents in order to see what the potential risks are. Now, just because you're a green card holder does not mean that you're 100% safe. And especially if you're applying for citizenship and your charge happened 87 years ago, if it's still just because it didn't get noticed at that time, it can definitely get brought up to the surface and noticed by immigration at this time if you apply for citizenship. So even if your misdemeanor happened 22 years ago, you've got to get the documentation and you've got to let an attorney analyze it. I mean, you can take the risk, but people have been known to be placed in removal proceedings from criminal charges disclosed at the citizenship application. If I get 2 years green card through marriage, but I was in an asylum case, can I withdraw my asylum case and travel to my home country from NUDA? NUDA, we don't recommend that, because if you have filed for asylum and even if you get your green card through a manner different than asylum, basically you may have problems in the future or even upon returning, because when you're filing for asylum, you're effectively saying that you're afraid to return to your home country. And a lot of people think that just because they've now gotten a green card, whether the green card is obtained through marriage or through through the asylum itself, that it's okay to travel to the home country. You just have to keep in mind that this is an issue that is going to surface itself, and it can jeopardize the green card that you already have. Grant Eugene, leave it. Thank you for the rose. I'm going to see if I can find your question. I'm due to process my citizenship, but we don't file taxes together. My advice, well, you don't have to file your taxes together if you're doing your citizenship, but you have to show proof that you're still living with your spouse in marital harmony. Vanessa, thank you. USCIS added 10 more months of my normal wait time for an I-130 petition from Belarus. It can happen if the processing times go up. Is there any way to speed up the process in an I-485 since the I-130 was approved in 01 from Stephanie? Stephanie, if you are a preference category relative, then there's no way to speed that up. But if you're an immediate relative is a spouse, parent, or child under 21, unmarried child under 21 of a U.S. citizen. For that, if your I-130 was approved in 2001, you gotta look into your case to see what's going on. Queen Rose, filed for VAWA in March of last year, and I've got a prima facie. How long before a green card? Queen Rose, about 3.5 years, give or take, okay? Let's see. Charlie Blake, I got 245I approved in 97 and I entered without inspection. Can I still adjust status? I have U.S. citizen children over 21. Charlie Blake, okay, section 245I. I'm confused. If you got 245I approved in 97, then you should be able to adjust status, okay? All right, so let's talk about section 245I. If you entered without inspection, but you had a family member or an employer try to petition for you before April 30th, 2001, you may qualify for something called Section 245I, adjustment of status. And what that will basically do is it will basically kind of waive, it'll take away that illegal entry of yours so that you can apply for a green card without having to leave the US. Now, Charlie, from your question, I can't tell if you actually filed it, or you just filed like some sort of application, something was filed for you in 97. Now, if you actually have something filed or you have this approved, then yes, you should be able to adjust your status through your U.S. citizen children. You need to show proof that you paid the penalty fee, and if you didn't, it's still not too late to do it. Okay, you can give us a call 212-248-7907. Omar. If you're married to an American citizen, is it advisable to file or apply for a green card after 1 year, 8 months in order to get a 10-year green card? Great question, Omar. So if you're married to a U.S. citizen, should you wait until you've reached, like a 2-year anniversary before you file, or should you just file right away? And my advice is always going to be that if you are eligible for anything, file it now. Don't wait until tomorrow. You don't know if the laws are going to change tomorrow. You don't know what problems are going to arise tomorrow. Get it done now, especially with this Trump administration and the way that they're treating immigrants. Having that protection of a receipt in your back pocket to show that a case is pending is going to protect you a lot more than you think. It's not always going to prevent you from getting arrested, but it can help get you out of detention, okay? So if you are married to a U.S. citizen, and you're thinking, okay, let me try to wait just so I'll get a 10-year green card, that's not always worth the risk, Omar. I think it's much more sound to apply sooner rather than later, okay? VAWA, thank you for the crown. I don't see a question from you though. I'm trying to give preference to people who gave me little gifts. Leave it. I don't join people on lives. I'm sorry, but I appreciate you wanting to join. If you ask me for joining my live, I don't really do that. I'm a U.S. citizen. I filed an I-130 for my wife, and it's still pending more than 15 months. Can I sue USCIS? You can sue anyone you want, but it doesn't mean that the case will be entertained in court. It might get dismissed. Generally speaking, if you want to sue USCIS because you think your case is taking too long, the courts generally like to see that it's at least 2 years past the processing time. So 15 months is going to be considered normal at this point. I know you're a little impatient, but it's part of the wait. It's part of the wait. And frequently, I'm so sorry, but my U.S. citizens out there, you guys are so impatient because you think that it should happen right away, whereas the rest of the immigrant community knows how long these things take, right? 2 years, 3 years, 4 years. And I'm not saying that it's right, but it's not abnormal to wait that long, okay? How long is a green card holder supposed to stay in the US? Is it consecutive 180 days or 60 days times 3 visits from Dragons Create? Dragons Create and anyone who is a green card holder, there's generally 2 rules that you need to follow when you're a green card holder. One is you cannot leave the US for more than 180 days at a time. If you leave the US for more than 180 days, then basically it creates a rebuttable presumption that you have abandoned your residency, okay? The other rule, which really is for people who want to apply for citizenship, if you have a green card and then you want to apply for citizenship, the other general rule is that you need to have at least 180 days cumulative each year on the ground in the US. That's another rule. That's the physical presence rule. And then you have the continuous presence rule, which is, if you leave the US for more than 180 days straight, okay? Jude, hello, nice to see you. Are you able to provide letters to your clients to present to the DMV in Florida? KK, yes, we can, and we have done that in the past. So KK, if you're a client of ours and you're having problems getting your license at the Florida DMV, let us know and we'll give you a letter, okay? And that should work. We had to do that a couple of times and it's worked so far. Oh my gosh, Angela, thank you so much. Angela saying, I'm a client of yours. If I had not seen one of your Instagram reels one super late night, I would not have been able to visit my family last year. Thank you for all that you do. Angela, thank you so much. I'm so happy to hear that. Thank you for being a client. Thank you for being a client, Angela. What if I get divorced with a US citizen before green card approval? Can I file for VAWA from Sheikh? Sheikh, yes, you can. If you have suffered in your marriage to a US citizen, even if that marriage has ended in divorce, as long as the divorce is not more than 2 years old, then you may still be eligible to file for VAWA. And again, the general requirements for filing for VAWA is you must have suffered in your relationship. You must have suffered. Your marriage must have been made in good faith. You must have lived together for any period of time, and you cannot have any disqualifying convictions in the past 3 years. A lot of people think that just because they have an arrest that they can't do VAWA or they can't file. Simply not true. There are lots of waivers available, but of course, if you have any sort of criminal history, we have to get it analyzed. And also, if you have already been ordered removed by a judge because you failed your immigration case in court, you may still be able to do VAWA. We may still be able to reopen your case once the VAWA is approved to help you do your green card petition, okay? So you can give us a call, 212-248-7907. Okay. Can a 21-year-old son apply for their parents and sister to get the process to get them legal from VFaith? VFaith, this is a very, very good question. If you are a US citizen and you're at least 21 years old, here are the people that you can petition for. You can petition for your mom, for your dad, for your spouse, for your child, and for your siblings. However, there's some very, very important considerations to keep in mind. If you have a brother or sister that you want to petition and you're a US citizen and they are here in this country, it's not really going to be possible for you to petition for them. It's not really going to be a realistic way for them to get status, because when you're a sibling of a US citizen, you have to wait like 15 to 20 years sometimes in order to get your case processed. And also, if you are already inside the United States and you're here illegally without permission, and you're waiting for your US citizen brother or sister to petition for you, it's also not going to work because you're out of status. Frequently, if you're living overseas, you don't have any bars to re-enter the United States, and your brother or sister is petitioning for you from inside the United States, then that's a more realistic process, but that also takes 15 to 20 years, okay? Now, if you're a US citizen and you want to petition for your mom or dad, here are the things that we're going to be needing to look at. Number one, we definitely need to look to see, do you have enough financial sponsorship in order to sponsor them? But the other most important thing is to see what kind of entry does your parent have? Because if you're a child that wants to help your mom or dad get papers, then frequently we have to look to see if your mom or dad has a legal visa entry into the United States. And if they don't have that, if your parent does not have a lawful entry to the US, If they entered unlawfully through the border and they never talked to an immigration official to be allowed into the United States, that is called an entry without inspection. And that's where things become a lot more difficult, okay? If your parent does not have a legal entry and you're 21 years old and you want to petition for them, here are the types of cases that we have to look at. Number one, if you are in the military, then we might be able to do something called military parole in place. Or if your mom or dad ever had one of their relatives or an employer try to petition for them before April 30th, 2001, then they may be eligible for something called Section 245I adjustment of status. But if your mom or dad has more than one unlawful entry to the United States and they have the serious punishment of permanent bar, then we have to look at other cases that don't really involve family. And one of my top cases that I love to look at for clients, I often call this a miracle visa because people don't know that this is an option that may exist. And this visa is called the T visa. And there are so many immigrants that may qualify for the T visa across the United States, and they just don't know what it is. So what is the T visa? Well, number one, I want to tell you what you don't need in order to qualify. You don't need a legal entry, you don't need documents, and you don't need a US relative in order to qualify for the T visa. But this is what you need to consider. If you have ever worked for somebody who refused to pay you properly, who was racist, screamed at you, called you names, threatened you with immigration, refused to pay you properly, did not let you take breaks, if you work for somebody that made you work in unsafe, unsanitary conditions, if you work for somebody that you were essentially afraid of, then you may qualify for a T visa. If you were in a relationship with somebody who treated you like a servant, made you do all the cooking and all the cleaning and all the chores, and they threatened you with violence, if you did not listen to them, you may qualify for a T visa. And why is the T visa so important? Well, again, you don't need to have a US citizen sponsor you for this. And you don't need to have a legal entry. You can even have multiple legal entries and still get approved for this. You can have a false claim to US citizenship and still be able to do the T visa. This visa is something that not enough people know about. And one thing that you should also know is that even if you worked for somebody 10, 20, 30 years ago, if they treated you this way, the way that I want you to think about a T visa is that was there any time as an undocumented person that you worked for somebody who basically you felt like you weren't really working for them out of your own free will? You felt that if you had to work for them, otherwise you would get in trouble. You had to work for them because you felt that they might call immigration on you if you didn't listen. And you did whatever they said because you were afraid to say no to them. Then you might be eligible for something called a T visa, okay? And if you're a parent looking to see how you can, if you're a child looking to see how you can help your mom or dad, and your mom or dad does not have a legal entry, they have the permanent bar, they have lots of immigration problems, and you don't know what you can do for them, this is something that you should talk about with them, because more often than not, especially for my parents who have been here for 20, 30 years, they have been through a lot of things. They have worked in some really bad places, and your mom or dad, here's a telltale sign. If your parent does not want to talk to you about their working conditions, but you know that when they get home at the end of the day, that they look really depressed and they look sad and they've been hurt or they get sick, but they still go to work, it's not really because they're afraid to lose a job. It's because they're afraid to upset their employer. And that is the key to a T visa. If they're afraid to upset the employer, that is something that we have to talk about to see what options may exist for your mom or dad. They deserve to be living free of fear after all that they have done, okay? After all that they have gone through to provide for their family. And you can give us a call, 212-248-7907. Vanessa, thank you for the roses. Thank you for the roses. V, is not getting paid for work You did as an independent contractor enough for a T visa. From V, that's a good question. If you're working as an independent contractor but you're not getting paid, is that enough for a T visa? And the answer is going to depend on what else happened, right? Because a lot of times you might be working as an independent contractor, but you're still, somebody is still using your services. So the question, the point of inquiry is going to be, did that person obtain your services, and did you do all that work? Because also there's one more, sorry, I forgot to mention that if somebody obtained your work, if somebody took the labor out of you through fraud, like they promised you, I'm going to apply for a green card for you if you do this, if you continue working here, if you do all these tasks, if they tell you I'm going to pay you this much money if you do all these things, and they get you to do all that work, that's also considered labor trafficking, okay? So if you are working as an independent contractor for somebody, it just depends on what else happened. What did they say to you? How did you feel? Did you feel afraid, or did you get induced to do all that work because of some sort of promises they made? And that may be that might be the way to get the T visa case done, okay? V, give us a call, 212-248-7907. Get inspired. Did you write something? Somebody wrote, what a mean employer. What if I got fired by my sponsored employer and my H-1B expires in July? They want to terminate the H-1B. What can I do? From Get Inspired. Get Inspired. Now, unfortunately, when you're an H-1B or you're on any sort of work visa, if the employer decides to terminate, then they can do that. But what I have seen a lot is this. If you're on an H-1B and the employer, the unfortunate reality is that a lot of H-1B employers are kind of like, like they're very abusive and they're very exploitative. Like they know that you're basically dying for them to sponsor you for a green card. They can get you to do so much work, and they don't pay you properly. And they might even constantly remind you that your visa status depends on you listening to them. Those are classic signs of a trafficking situation, okay? So Get Inspired, feel free to give us a call if you think that might apply, and we can explore this case with you, okay? 212-248-7907, okay? All right, guys, I gotta get going. Nihar, current client, love the coffee and handmade candy. I hope you enjoy that, Nihar. What inspired you to practice law? From Nihar. Nihar, this is a good question. All right, this is the last question I will go ahead and answer. What inspired me to practice law? Well, I have been a politically active person my entire life. Through high school, through college, I have been very politically active. I have been very socially conscious. And something that I always noticed is that in law, in government, it's lawyers. It's a lot of lawyers. And what was the reason for that? Well, you have to understand how the laws work and how laws are created and how they're decided and prosecuted and all those things. And I really felt strongly that if I wanted to affect social change in this world, I needed to understand the law and be a lawyer. That plus also my mom was an immigration paralegal, so she did inspire me to pursue law as a career as well. But really, at the end of the day, it was really my motivation for fighting for equal rights, for fighting for human rights, for making the world a better place. And maybe it's funny or not, I don't know, but that's why I decided to go into law. Okay. Anyway, I hope you all have a wonderful night. Thank you for joining. I'm sorry I could not answer all the questions, but hopefully I'll see you guys here again soon. And honestly, if you're worried about, if you want to find out if you qualify, please give our office a call. 212-248-7907. We'll ask you some questions to see if your situation maybe falls into one of the type of cases that we work with. And if we can do that, then you can book an appointment for a case evaluation with us. The fee is $150. However, if we can't work with you, we'll refund you the money. And if you do decide to hire us, we'll apply that towards your fee as well. So you've got nothing to lose, okay? 212-248-7907. Okay. I will go ahead and say good night and wish you all blessings. Good night.